Jones joining us for what I find to be a very interesting topic, and very much looking forward to learning a ton today during today's event. I also want to welcome Audrey Marlowe, who's our marketing director and holds everything together for us and in scheduling and otherwise. If you ever have any questions, please feel free to reach out to her directly. We also have on a few other directors that I want to mention. Deborah Burke, Rebecca Hannevice, and Mary Hardy are all on as well. So if you ever look forward to seeing everybody at events throughout the year. I'll do a quick plug for the all-day Lollapalooza MCLE event that's happening at the end of the month on the 26th of April. It's happening at Rancho Bernardo Inn, which is a great setting for this type of event. You know, there'll be breakfast, lunch, a lot of networking, and then a happy hour with heavy hors d'oeuvres and folks like Pettit, Kohn, gold and platinum sponsors will be presenting during that day. So we're really looking forward to that and encourage everybody to join. It's really a fun event, and you get a lot out of it, not only from your peers and from our sponsors, but from the content that we work on for the better part of the year in making sure that it's relevant and timely. So with that, I'll turn it over to Caitlyn. And again, thanks for everybody joining.
Okay, thank you all so much for being here. This is a topic that I am excited about and excited to present. I spoke at Lollapalooza last year on ethics for in-house counsel. And I told Sven before we started, whenever we present on ethics issues, there are always some people who come up afterward who want to ask some questions privately. And typically that's because something in the presentation has spurred a concern for them, or a thought that maybe there was something they missed, or they're actively in a conflict type of situation and they're not sure what to do. And almost always those questions are about conflicts of interest. So I thought it was time to develop a more in-depth presentation that specifically speaks to the various types of conflict that can occur, some best practices for working through those conflicts and avoiding them altogether, and just talking about the intricacies of the relationships that arise in the corporate context. I'll be happy to take questions today through the chat feature or through Q&A. Feel free to send them anytime, and I'll look at all of those as I can. So this is me, Caitlyn Jones. I primarily do legal malpractice defense. So I'm in the business of helping people avoid conflicts and helping them once they have been sued for oftentimes conflict issues. We also do a lot of business litigation and general commercial liability, but legal malpractice is sort of where my heart lies. So today we'll be talking about understanding conflicts as they're presented in the rules of professional conduct, identifying and assessing actual and potential conflicts so that you feel more comfortable understanding if a conflict is going to arise, maintaining clarity in the attorney-client relationship, particularly in the corporate counsel context. It is not always as clear as it seems who your client is and who falls within the scope of your client, because many of you represent organizations who speak through their directors. So we'll talk a little bit about how to maintain that clarity. We'll talk about scenarios in which conflict arises between clients, inter-client scenarios, for example, representations of parents and subsidiaries at the same time. We'll talk about intra-client conflict. So that is obviously conflict that occurs within your organization when you receive conflicting directions or when management asks you to represent them in an investigation. And then we'll talk about the more rare but still important attorney-client conflicts where corporate counsel becomes, for example, a whistleblower against their own company. So let's start with the rules. Rule 1.7a is going to be your guide for conflicts of interest. And this rule says that a lawyer shall not, without informed written consent from each client and compliance with paragraph D, which we'll talk about, shall not represent a client if the representation is directly adverse to another client in the same or separate matter. So this refers to inter-client conflicts, conflicts that arise between two different clients. And comment 2 to this rule specifically speaks to the partnership and corporate context and says that the words same or separate matter apply to circumstances such as the formation of a partnership So that means that if you are representing two partners in the formation of a partnership, you need to work through this rule to ensure that you're following the correct procedures. And like I said, this frequently arises in representation of multiple partners whose interests eventually do turn conflicted. Rule 1.7b goes on to say that a lawyer shall not, without informed written consent from each client, and again, compliance with paragraph D, represent a client if there is a significant risk that the lawyer's representation will be materially limited by the lawyer's responsibilities to or relationships with another client, a former client, or a third person, or by the lawyer's own interests. So this speaks to intra-client conflict, where your pending potential representation of another individual within your organization, perhaps an employee or a constituent of your organization, may conflict with your existing responsibilities to the organization or the company itself. And it also speaks to attorney-client conflicts where your own interests conflict with those of the company. And this can occur when a lawyer is a director of a company, of a corporation, or when a lawyer becomes a litigant against their client. So Rule 1.7d, this is your compliance portion. This tells you how to go about representing clients with conflicting interests. And it says that representation is permitted only if you believe you can reasonably provide competent and diligent representation to each client. The representation is not prohibited by the law, and the representation does not involve the assertion of a claim by one client against another client in the same litigation or proceeding. Now, point 2 is one that doesn't come up that often, where representation is actually prohibited by the law. There is a portion of the Business and Professions Code that explains that, for example, former prosecutors may not consult with the defense on a case that they were personally involved with. But the more appropriate and more commonplace way that this arises is when you have what's called a non-waivable conflict. So that would occur, for example, there's a case, Cram versus Superior Court, that says that if you represent one client in one matter and you represent another client in the same matter, and those two clients have conflicting interests, there cannot be informed consent as a matter of law. The informed written consent. The consent cannot be intelligent and cannot be informed because the interests are directly adverse. So that's when you would not be able to take on dual representation. So you need to assess whether you have an actual or a potential conflict before you undertake any representation outside that of your primary corporate client. How do you identify an actual or a potential conflict? There's a two-part question that kind of helps to formulate the response to this. One, what is the likelihood that a difference in interest between the two potential clients exists or will arise? And two, if such a difference exists or will arise, will it foreclose courses of action that you should reasonably pursue on behalf of one or more of your clients? Also consider your duties of confidentiality and your duties of loyalty. Those are the primary duties that are implicated in conflicts analysis. So remember, you have a duty of confidentiality to your client. If you take on another client and your representation of that new client would require you to disclose something that you learned in confidence from a previous client, you may not take on that successive representation because you cannot reasonably represent the new client without disclosing your previous client's confidences. Similarly, you have an undivided duty, a duty of undivided loyalty to each of your clients. And so if you consider taking on an additional client at the same time as your corporate client, and that representation would require you to oppose your existing client, then that violates your duty of loyalty and you may not take on that representation. So how does conflict generally arise in a corporate context? I mentioned this a little bit earlier, but you have inter-client conflicts. This happens when you represent parents and subsidiaries at the same time, when you represent joint partners, or when you represent a company and an employee, company and a director. Intra-client conflict, which is really where we'll focus today, that occurs when you have disagreement among the constituents you report to. You have disagreement between two partners in their partnership dispute, or you have a corporation that's going through a divorce. Where does the attorney take their direction during these periods of conflict, and what are some of the best practices to avoid missteps. And finally, as I mentioned, we'll talk about attorney-client conflicts, particularly in the roles of attorney as director of a corporation, where you act as both attorney and client, attorney as a whistleblower, for example, with Sarbanes-Oxley, having to report your own client for violations of the law, which trump your state privilege rules, and attorney as litigant when you have to sue your client for wrongful termination, or when you get sued for, unfortunately, legal malpractice. So all of these questions about conflict have to start with the question of who is your client. You need to clearly identify who is your actual client and who speaks for your client. So Rule 1.13 tells us when the organization is a client that the lawyer employed or retained by the organization shall conform his or her representation to the concept that the client is the organization itself, while it acts through its duly authorized directors, officers, employees, and members. Those people are not automatically your clients. And a leading case on this issue is Meehan versus Hobbs, in which the court opined that the attorney owes the undivided allegiance only to the corporate entity rather than to its affiliated persons and entities. So the question arises commonly, do you have a fiduciary duty to the constituents in your organization, even if you don't represent them? And this question somewhat depends on the nature of your organization, but generally the answer is no. In partnerships, generally you have no fiduciary duty to the limited partners. However, as attorney for the partnership, you have a duty to look out for the interests of the partners to the extent that they have entitlements to the benefit of the partnership. Similarly, you have duties of disclosure. So if you represent a partnership and one partner gives you information that is material to the partnership, you may not withhold that from another partner because you have a duty of disclosure. For corporations, generally speaking, you do not have duties to minority shareholders. We'll talk about some circumstances where you may have fiduciary duties to a sole shareholder or a majority shareholder. But generally speaking, you do not have fiduciary duties just because you represent the corporation. And as far as limited liability companies, these can be a little bit more difficult. Generally speaking, once again, you do not have fiduciary duties to individual members or managers of the LLC. However, through your words and actions, you can imply to a member that you are representing them personally, and that can create an attorney-client relationship between yourself and the member. So one of the themes of today's presentation will be that all of your attorney-client relationships should be intentional and not accidental. So we'll talk about some ways in which accidental representation can occur, and this can happen in the context of limited liability companies. But generally speaking, you do not have fiduciary duties to the constituents just because you represent the organization. Now, the question also often arises, can you represent both an organization and its constituents? And here the answer is yes. A lawyer representing an organization may represent some or all of its constituents, as long as you're complying with the rules of professional conduct, particularly Rule 1.7, and that generally means assuring that you do not have a non-waivable conflict and obtaining informed written consent. If the organization's consent is required, you may not get that from the person who is your other client. So if you're representing corporation and CEO, the CEO may not be the person who signs the informed written consent because obviously their interests are at heart for both of those. So you need to find somebody else who can speak for the corporation to sign the informed written consent. And you may only represent company and constituents to the extent that their interests are aligned. As I mentioned before, once the interests become adverse in the same issue, you may not represent them simultaneously. So why the identity of your client matters? I opened by asking you, who is your client? When your client is an organization, the people who are within the scope of the client determine whether you can disclose information to them and whether you must disclose information to them. Assessing who speaks for your client is important when there are disputes between management or internal organizational issues arise, because you have duties of confidentiality. So if one constituent comes to you and tells you something and they believe they're telling you in confidence, but you have a duty to share that with other constituents, you need to be really clear about who speaks for your client. Generally speaking, you look at your organizational documents. They should indicate who is authorized to speak on behalf of the company. Generally speaking, those people are within the scope of who speaks for your client, and other people within the organization are not. Ensuring you're communicating with, quote, the client is also important because it ensures your communications are privileged. Now, the important caveat here is that your communications with your client are only privileged insofar as they are, the dominant purpose is seeking legal advice. So many corporate counsel hold dual roles, even triple roles as financial advisors to a corporation, as business advisors to a corporation. It's important to know that when you're communicating with your client, if the dominant purpose is business advising, those communications may not be confidential. They may not be privileged. And I've actually had a couple significant cases in which I was able to obtain corporate counsel's communications with employees and constituents because they were related to matters outside the scope of seeking legal advice from the company. So it is an area that you need to be really careful in. Additionally, only clients have standing to bring malpractice cases. So again, you can create implied attorney-client relationships, and we'll talk about that. But more often than not, individuals within the organization who do not fall under the scope of your client are not going to have standing to bring a malpractice claim. And so all of this leads to why it's important to maintain clarity in your attorney-client relationship. It is actually codified in Rule 1.13F, which says that when you're dealing with your organization's constituents, the lawyer for the organization shall explain the identity of the lawyer's client whenever the lawyer knows or reasonably should know that the organization's interests are adverse to those of the constituent with whom you're dealing. This occurs in the corporate context, particularly in the case of terminations. If the corporation has issued a notice to an employee that some kind of adverse action is being taken, and that employee comes and seeks advice from corporate counsel about that notice, the interests of the organization are likely adverse to the interests of that employee, and you cannot competently represent both the corporation and that employee at the same time. So you need to be cautious of giving advice to the employee in that context. So now we'll talk about inter-client conflict and some of the scenarios where this arises. Common scenario is where parent and subsidiary companies are both involved in a deal or in litigation, and the same attorney represents both of them. It also happens where partners to a partnership develop conflicting interests. In my world of legal malpractice litigation, we see this a lot with corporate counsel who decide to take on representation of an employee in ongoing litigation. So a company is sued, and in the course of the litigation, the opposing counsel notices an employee for a deposition, and the company says in-house counsel will represent the employee in the deposition, or corporate counsel will represent the employee. That's a scenario that leads to a lot of conflict. Additionally, representing directors or management in investigations, occasionally there is no conflict and it can be done appropriately, but it also is an area that's fraught with conflict. So in the scenario where the parent and subsidiary are adverse, here's a common scenario. Attorney Smith represents Company A, which is a big publicly traded company. Company A has a wholly owned subsidiary, Company B, which the attorney does not represent. A third party comes in and asks the attorney to bring a lawsuit against Company B, and Company A will not be part of the lawsuit. Does Attorney Smith's lawsuit against the subsidiary, Company B, constitute a conflict? The prevailing view here is that the mere fact of corporate affiliation does not create a conflict itself, as long as your confidentiality and loyalty issues are in line. So the State Bar actually issued a formal opinion about this, 1989-113, and it's applying the old rules of professional conduct, but the gist is the same, and that is that an attorney does not represent conflicting interests when he or she acts adversely to a wholly owned subsidiary of an existing corporate client. And the point is that if the attorney takes on a representation that has only a very tangential effect on the existing client, that's not considered to be a conflict. There are two exceptions to this rule, and one is the alter ego rule, where there's sufficient unity of interest so that the parent and subsidiary are effectively the same company. And second, and this is always going to be the case, where an attorney has received confidential information from one of the parties, they may not then use that confidential information against the party. The reverse is also true. So representation of a subsidiary creates no attorney-client relationship with the parent just by virtue of a representation alone. There's a case, Brooklyn Navy Yard, in which the court found there was no conflict when an attorney for a subsidiary sued the parent in an unrelated matter. So this scenario is one that I touched on. This actually is probably the most common place that we see real conflict issues arise. And that is when corporate counsel takes on the representation of an employee of the company for a limited purpose. So here's a scenario from a real case. Big company conducts an investigation into an accident at its factory. Witness Y speaks to the investigator and says, no, big company didn't do anything wrong, they're not at fault. So witness Y is identified as a witness in the case, and company says in-house counsel will represent witness Y at their deposition. And during deposition prep, witness Y tells the attorney, I lied to the investigator, and in fact, big company is at fault. And the attorney continues the representation and says, that's okay, just testify truthfully and everything will be fine. Do you have a conflict of interest? And this is a resounding yes. This is a non-waivable conflict between counsel and employee. This is from a real case, Yanez versus Plummer. And the attorney was driving to the deposition with the witness when the witness told him that he had lied to the investigators. And the attorney told the witness, just testify truthfully, tell the truth, and everything will be fine. The witness was, he did testify truthfully. He said that he had lied previously, and he said the company was at fault. And then he was fired, and he sued the attorney for malpractice for not disclosing a conflict of interest, and he was successful. The reason this is a non-waivable conflict is because you place yourself in a scenario where in order to competently represent your existing company client, you need to cross-examine the witness that you've just decided to represent for their deposition. Whenever you are in a scenario where you need to cross-examine your own witness, you have a very conflict-ridden scenario. If the employee testifies that the company is not at fault, then you know that that testimony is false, and that implicates a whole different set of rules of professional conduct about suborning perjury. And as in Yanez versus Plummer, if the employee tells the truth and they have adverse consequences from the company, you have a malpractice problem because you have failed to disclose your conflict of interest. Another scenario where this arises is the representation of management. So we're going to talk a little bit about how the more closely held a corporation is, the smaller a partnership is, the more intimate your relationship is with the director or shareholder, the more likely it is that you have or are developing an attorney-client relationship with them. So when an attorney represents a corporation dominated by a single officer or an LLC dominated by a single member, and that person's interests are essentially the same as the interests of the company, do you automatically have an attorney-client relationship with that person? And the answer is no. Always and forever, the rule will be that the attorney for the corporation only represents the corporation with no other facts alone. You do not represent owners, shareholders, CEOs, anyone else in their personal capacity, unless there are facts giving rise to an additional attorney-client relationship. This is important to keep in mind because you are not disqualified from representing that company against its shareholder, director, member, if that person does something that is illegal, unlawful, gives rise to some type of injury. So you always have to keep that in the back of your mind, even as these people are conveying to you confidential information in the course of their duties in their business, that confidential information could, in theory, be used against them at some point in the future, so long as you have not developed a unique attorney-client relationship with that person. So you may, in theory, be in a scenario to use information against that sole director, member, shareholder, officer. However, as I cautioned, with closely held corporations and partnerships, where you've worked intimately with the sole owner or the two partners together, this does create a difficult ethical issue. And the cases on these issues are kind of a classic lawyer issue of it depends what the facts show. There are many ways in which counsel can interact with a constituent of an organization that give rise to an implied attorney-client relationship. And so one example here was in the Hecht versus Superior Court case, where counsel represented a very small partnership that was jointly owned by a husband and wife. When those two spouses divorced, the court disqualified counsel from representing one of the spouses in the divorce. Even though it was a separate matter, both of the spouses were found to be the client of the attorney, even though they had not individually signed any type of retainer agreement, because the partnership was so intimate and so closely held. So all of this leads up to implied attorney-client relationships, which is something that we really want to avoid. In-house counsel, corporate counsel, any kind of attorney really can create an implied attorney-client relationship, and it does give rise to malpractice liability for undisclosed conflicts. And that is because if the person that you are speaking to believes they have an attorney-client relationship with you, but you don't necessarily believe you have an attorney-client relationship with them, it is almost a given that you have not adequately disclosed the conflict that exists, and therefore, should they rely on your advice, come to find out you do have a conflict, you've got an issue. So there's a couple cases that discuss the factors that the courts will consider in trying to determine whether there's an implied attorney-client relationship. The responsible citizens case is the leading case on this, and the court really just goes through the totality of the circumstances. They look at how big is the organization, how intimate was the relationship, what was the original engagement. So for example, if you were originally engaged by one partner to represent them personally, and over time you become the attorney for a partnership, the court may look at that original engagement letter and find that you have an implied relationship with that one single partner, even if you now only represent the partnership. Your access to information from one of the partners or one of the constituents, all of that are all of those are the totality of the circumstances the court will consider in trying to determine whether an implied attorney-client relationship has arisen. And the Sprengel case, I mentioned it earlier, is an interesting case because it's an LLC and it had two co-owners of the LLC who were fighting over rights. And the court looked really closely at whether the attorney conducted himself in such a way as to make one of the owners believe that the attorney represented the owner personally. And the court ultimately found that the attorney had not conducted himself in that way. So best practices to avoid implied attorney-client relationships and these conflicts that arise between multiple representations. One, if you are not undertaking an additional representation, for example, you represent a company and you are not representing employees individually, you need to give the upjohn warning and you need to document your giving of the upjohn warning. So the upjohn warning is the corporate Miranda that tells the constituent with whom you're dealing, I don't represent you, I represent the company, I don't have attorney-client privilege with you, the privilege belongs to the company alone. Anything you tell me, I may disclose to the company, and in fact, the company may choose to disclose what you tell me to a third party, to an investigator, anything like that. So you need to give that. And you need to document that you've given that, because when the person comes back around and says that you gave them legal advice, you have a document in your file that says that you adequately advise them of the conflict and that you are not representing them. If you are going to undertake dual representation or successive representation, you want to obtain conflict waivers from your clients, and you want to obtain informed written consent. So I do this all the time. I frequently represent law firms who've been sued for malpractice, and I also represent the attorneys in the law firm, sometimes or frequently a partner or a shareholder and an associate at the same time who worked on the underlying matter. At the outset of the case, it appears that everybody's interests are aligned. I always tell them there may come a point in the case where your interests are no longer aligned. This happens where everyone says nobody did anything wrong, everybody did everything just right. And then as the facts develop, the associate says, well, the partner told me to do that. I didn't know it was wrong. All of a sudden you have a very significant conflict of interest and you cannot continue to represent both of those parties at the same time. So at the outset of such a representation, you make a disclosure of your potential conflict. You explain how the conflict may arise. You explain that there may be a time when you can no longer proceed with dual representation. And really importantly, you highlight which person will stay your client. So if you represent a partnership and you go on to represent both partners and the partners dissolve, you want to have something in there that says, in the case of the partners no longer agreeing, I represent partnership, or I represent partner A, and partner B agrees to waive any argument that there's a conflict. So that will protect you from, down the line malpractice claims that you failed to disclose your conflicts adequately. And whether you are taking on additional representation or declining additional representation, you want to discuss confidentiality issues. You want to make sure the person that you're talking to knows whether they have a confidential relationship with you or not. Same with privilege. You want to discuss the potential for conflicts to arise that you don't even know about yet. And you always want to advise them to get a second opinion. It doesn't harm anybody for that person to seek an outside opinion as to whether there's a waivable conflict or not. So moving to conflicts within the client, some scenarios where this can arise. Constituents are in disagreement over the direction of the company or the corporate governance. A particular problem is when your constituents act in a way that's unlawful or harmful to the organization, or they demand that you act in a way that you know is unlawful. Or again, when you represent multiple individual interests within a partnership or a corporation. So when your constituents disagree, this is probably the most common question I get. What do I do when I have been told to do something by one director and I've been told to do something different by a different director and I see no clear path forward? So first, you want to look at the applicable statutes. If the Business and Professions Code has a rule about this, typically it won't, but sometimes it does. And then you want to go to your organizational documents and review your partnership agreement or your, whatever formation documents the LLC has or the corporation has to see if there's an answer about how to proceed if there's a split in the directors or the managers. If that's unavailing for you, try to work with the partners or the directors to resolve the dispute, making sure that you're advising of the consequences of failing to resolve it. So you want to make sure that the two partners or the two directors understand that you cannot act until the dispute is resolved. So there may be statute of limitations issues. There may be a lost business opportunity because you are waiting for them to resolve their discrepancies in order to act according to the desires of the corporation. And if the dispute cannot be resolved, you may withdraw if the dispute renders it unreasonably difficult for you to continue representing the partnership. The most important thing is you cannot act on the instruction of one partner or one director if a dispute between the people who speak for your company and your client remains unresolved. So that's when constituents disagree, but how about when they do things that are illegal? Thankfully, the rules do provide steps for the attorney to take if your client is, or your constituents of your client are acting in a way that's unlawful. Rule 1.13 requires that you report up, it's called reporting up the ladder to the highest internal authority, any conduct that you know of, or that any conduct that you know of that is a violation of law, or you should know it's a violation of law. That's one of those catchphrases, know or should have known, that's difficult for attorneys to parse. But if you suspect something is a violation of law, then Rule 1.13 requires you to report up under certain circumstances. So a common example is unlawful employment practices. If you know that your company is putting a clause into its employment contracts that is illegal under California law, you are required to report that to the highest internal authority, and you may not participate in giving of that contract to potential employees. So there's a two-part test under Rule 1.13 for whether you are required to report up. Part one, do you have actual knowledge of something that is occurring or that someone is planning to do something? And two, would a reasonable lawyer conclude that what that person is planning to do or doing is a violation of law or a legal duty, and it is likely to result in substantial injury to the organization? So the example of an illegal contract provision is apt because you know that it's in the contract. A reasonable lawyer would conclude that giving a potential employee an illegal contract provision is a violation of the law. And if you get sued, well, you're liable because it's illegal in the contract. So that rule would be met and you would be required to report up. So who is your highest internal authority? Generally speaking, for a corporation, it's your board of directors. For a limited partnership, it's your general partners. And for an LLC, it's usually the manager or the managing member. Okay, sometimes reporting up fails. Sometimes you do report to the highest internal authority and nothing happens. This Rule 1.13 does allow you to resign or withdraw if necessary. And in some circumstances, it requires you to. Usually that's in the case where you know a corporation is engaging in a fraud, like a Ponzi scheme. Now, sometimes constituents agree on the course of action, but the course of action they agree to is, in your estimation, against the interests of the company or the organization. So we've talked about corporations can only speak through their members and their principals. Do you have to accept the actions or the decisions of the directors, even if they are contrary to your advice, and if they appear to be, harmful to the interests of the organization? Generally, the answer is yes. Generally, lawyers are not tasked with making the decisions for the organization. Comment 2 to Rule 1.13 says that lawyers ordinarily must accept the decisions of their constituents, even if you question their utility or their prudence. So it looks like we have a question from Sven. Oh, so after giving the upjohn warning, what is the best practice on how to document that it was given? So the malpractice lawyer in me says that you should have a written upjohn warning, and you should provide that to the person for signature, and you should maintain a copy in your file. Some, more smaller or more family type of organizations may find that to be too aggressive and too impersonal. And where that's the case, I would just say have a minute taker take the minutes of the meeting. Generally, interviews between corporate counsel and employees as a part of an investigation should have some type of recording. I don't mean literally video recorded, but I mean that it should be recorded that that interview occurred and that certain warnings were given, and that should be maintained in counsel's files. So remember that even though you may not have to report up, you still have a duty to inform. So you always have a duty to inform your client of significant developments related to the representation. So where your constituents are doing something that you think, this may not be in the best interest of the company, but it's not illegal, so I don't have to report up, you can still choose to report that. And in fact, you should, if you believe that it's going to have a significant effect on your client. So Rule 1.13 says you may refer to a higher authority any matter that you reasonably believe is sufficiently important in the best interest of the organization. And so now comes the sticky part, when the highest internal authority is the actual wrongdoer. This may happen when you have a solo corporation and the director is using the corporation to carry out a fraud. What do you do? Well, the answer always is you withdraw if you have to. if the only person in control of the corporation is running some kind of fraud, you have a right and sometimes a duty to withdraw. The duty part comes in when that person would be asking you to take steps that are illegal. You may not do that as an attorney, so you would have a duty to withdraw. And an example of this is Meehan versus Hobbs. That was one of the cases I discussed in the beginning. And in that case, the court actually found that the attorney for the corporation could act as counsel for the receiver against the director and chairman in the best interest of the company. So you should always keep in mind that that is a possibility for you in representing your company, that you may someday represent it against its own directors. Corporate divorce happens less often, but generally speaking, it's a good practice not to represent any one party when you also represent the company. Same with partnerships. It's generally not advisable to represent one partner in a partnership dissolution if you also represent the partnership. You can represent the company and a shareholder so long as their interests align. And there's a State Bar formal opinion 1999-153 that specifically discusses that you can represent company and shareholder A against shareholder B, so long as you're following Rule 1.7, and so long as company and shareholder A's interests remain aligned. The moment they become adverse, you have an unwaivable conflict. So like I said, you always want to look ahead to the potential for representation of your company against one of its members, and ensure that your communications are cautious in not creating an implied relationship with a constituent that you don't want to have that relationship with. So finally, we'll talk about attorney-client conflict. This doesn't come up as often, but when it does, it's pretty severe. So it's something that's good to be aware of your rights and your responsibilities. So sometimes you may have to whistleblow on your own company. Generally speaking, the whistleblower protections that are under federal laws, particularly Sarbanes-Oxley and Dodd-Frank, take precedence over your state-imposed attorney-client confidentiality and privilege rules. So while you have the highest duty of confidentiality to your client and duty of loyalty to your client, if you know that they are violating Sarbanes-Oxley or Dodd-Frank or a significant federal fraud provision, you may blow the whistle on them, and you may use your confidential and privileged information to do that. Be aware it's going to get sticky fast, but it is something that you are allowed to do. A great case of this was Wadler versus Biorad. This is kind of the case on this issue where the counsel asked an independent audit committee to investigate management of the company that he represented for violations of the Foreign Corrupt Practices Act. The audit committee did investigate and they found no evidence of misconduct. Counsel was fired and counsel sued for whistleblower retaliation and wrongful termination. And the company tried to exclude all potential evidence on the grounds that all of their communications with counsel, all of the information they had provided him over the years was all privileged. And the court actually said, no, it's admissible because one, whistleblower protections, and two, he has a right to defend himself in this case. And therefore he has a right to disclose what he relied upon, the communications and the information he relied upon in making that, taking that step. Another issue where attorney and client, attorneys can develop conflicts with their own client is when they are directors. It's kind of a newer phenomenon, I think, to see general counsels on boards of directors. I think that there's more of a push for those dual roles. It is an opportunity for conflict to arise. In particular, as I mentioned earlier, whatever you do in your role as a director is not privileged. You would have to really carefully document whether your communications on any particular subject are legal in nature or business in nature. To the extent they are business in nature, they just simply will not be privileged and they will be subject to disclosure. It's a little bit strange because you'd be forced to consider your own personal interests alongside those of your client. They may be the same, but as always, conflict may arise, and that puts you in a very uncomfortable position. You may have to take a position that you believe is in the company's best interest against your fellow directors on the board, which again puts you in an uncomfortable spot. And you become attorney and client to yourself because you represent the company which speaks through its board. So in a sense, you are speaking for yourself as a client to yourself as the attorney. So it can be done, but it should be done with great care. Sometimes you become a litigant against your own client. If you're wrongfully terminated, like we saw with Wadler versus Biorad, you may be able to divulge your confidential client communications in order to pursue your wrongful termination suit. This happened in Fox Searchlight Pictures. Former counsel was allowed to disclose everything she needed to that was relevant to her termination, even though the company claimed that it was privileged because she was counsel for the company. The court held that she could disclose it to pursue her case. And finally, my favorite topic, legal malpractice. So if you are sued by your client for legal malpractice, generally speaking, all bets are off in terms of privilege and confidentiality. You have a right to defend yourself, and you have a right to use all evidence that you have at your disposal to defend yourself. You may still have privilege issues as they relate to matters outside of your case, but generally speaking, your communications with your client that are typically confidential and privileged are no longer confidential and privileged to the extent they relate to the subject of a legal malpractice matter. So your hands are not tied in the sense that you can disclose what you need to disclose to defend yourself. And these are some evidence code and business and professions code sections which explain that there's an exception to the attorney-client privilege for malpractice defense and some cases that deal with that. So with that, if anyone has any questions, I'd be happy to take them through the chat. Doesn't look like anyone has any. If any questions occur to you that come up in the course of your representation of your clients, or any conflict scenarios that you're not really sure what is the best practice to avoid some type of conflict, please feel free to email me or call. I love conflict issues and I'm always available to work through them. So thank you.
Caitlyn, thanks so much. I got 3 great nuggets out of this that I hadn't had before. So this was really informative as in-house counsel. So for a corporation that works, internationally, really great. Loved it. Thank you very much. And thanks for everybody that was able to join. We had great participation. A lot of people showed up for this event. So it's a testament to the value that Caitlyn provided from a conflict standpoint. It's just great.
Thank you so much, everyone.
All right, everyone.